Welcome to part three of chapter nine, Intellectual Property, which is contained in The Legal and Ethical Environment of Business by Terence Lau and Lisa Johnson. And this is Dr. J. Kent Gregory, and I will take you through part three, which covers copyright. So, copyright is designed to protect creativity, and it's one of the two types of intellectual property mentioned in the Copyright Clause of the U.S. Constitution. And it extends to any form of creative expression, including digital forms. And this is an interesting topic now, particularly with sale of digital art and the ownership of those copyrights. So a work must be original and fixed in a durable medium to be copyrighted. So ideas can't be copyrighted, but the written word can be. Uh, Art can be. Music can be copyrighted. Uh, Copyrighted work is automatically copyrighted upon its creation. So authors or artists, the creators, don't have to send their work to the government for approval. Although it is a good idea to write copyright or place the copyright symbol in the work, it's not legally required. Copyright protection lasts for 70 years after the death of the author. And if there's more than one author or creator, the copyright expires 70 years after the death of the last surviving author. If a company, such as a publisher, owns a copyrighted work, the copyright expires 95 years from the date of publication, or 120 years from the date of creation, whichever comes first. And after the copyright expires, the work falls into the public domain. The owner of a copyright may allow members of the public to view or use a copyrighted work for free or for a fee. So the end user license agreement. This is a contract between a copyright holder and a user, and it's typically typically used in software licenses. So a license is permission from the copyright holder to violate, essentially, the copyright within the terms of the license agreement. The GPL is a widely used free software alliance. Creative Commons is a nonprofit organization dedicated to the free distribution of creative content and a publisher of several standard copyright licenses. First sale. This is the doctrine under which the first owner of a piece of copyrighted work can do whatever he or she pleases with it, including resell the work. Licenses in the digital arena can be very restrictive if the digital media is purchased. So copyright holders may use schemes such as digital rights management, limit ownership rights in digital media. And DRM is a scheme to restrict the ability of an end user to copy or modify digital media. Copyright infringement. This occurs when someone uses a copyrighted work without permission or violates the terms of a copyright license, or a person assists someone in violating it, or creating a device that assists in violating the copyright. Copyright law makes a distinction between fair use and infringing use. And fair use includes copying of a work for the purposes of commentary, criticism, news reporting, teaching, and research. The law provides 4 factors that courts must consider in determining whether or not the use is fair: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market for the copyrighted work. So the Digital Millennium Copyright Act was an attempt to address the problem of copyright infringement on the internet. And Congress passed this, the DMCA, in 1998, which, you know, if you think of the internet, that was an eternity ago. Here we are sitting in early 2021. So it was a federal law outlining any attempt to circumvent a copy protection device or scheme, and it makes it illegal to attempt to disable a copy protection device. So that wraps up Chapter 9, And I hope you enjoyed it. And thank you very much.